Alright, so this is This We the People News one more time. Okay? I've just been busy, so I haven't been making very many videos. But I took a little break of study and researching and making this video here. Now, in my past videos, I always said, to kind of always challenge the cops, instead of taking you to jail, to take you to the magistrate. Okay? And demand it 3 times plus, but make sure it's minimum 3 times. All right, just like you invoking your Fifth Amendment, you got to invoke it. You got to speak it. You're invoking your Fourth Amendment. You're standing on the Fourth Amendment. You got to invoke it. All right, or silence acquiescence, and you consented to whatever the officers are doing to you. Okay, this is for anything and all things that has to do with officers. Okay, stand on it, invoke it, because you're being silence acquiescence and you tacit agree to the officers' terms. Do not agree with officers. Officers don't agree with you. They don't even apologize. Why? Because now they go into being in the wrong, operating in bad faith, so they will not do that. All right. Most of them won't. Accidents happen sometimes. We're all human. Wink, wink. Okay? So, that being said, I want to kind of draw a little snippet. Why? Okay? Let's go. And you're going to have background sound this middle of the day. Grandbaby's up, playing around.
Which further stipulates the conditions in which an arrest can be made without a warrant. Authority of peace officers. Any peace officer may arrest without a warrant persons found in suspicious places under circumstances which reasonably show that such persons would have been guilty of some felony, violation of Title 9, Chapter 42 Penal Code, breach of the peace, or offense under Section...
Okay, this is going to be Texas code, so you're going to have to look up your other codes. Okay? And people that's watching, or the people that's doing cop watch and all that, and doing audits, remember this, write it down, and follow up what state you are in, because all states are basically like this.
Section 4902 Penal Code, or threaten or about to commit some offense against the law. Persons who are peace officers has probable cause to believe have committed an assault resulting in bodily harm to another person, and the peace officer has probable cause to believe that there is danger of further bodily injury to that person. Persons who the peace officer has probable cause to believe have committed an offense defined in Section 2507 Penal Code if the offense is not committed in the presence of the peace officer. Persons who the peace officer has probable cause to believe that committed an offense involving any family violence. See, the family violence is different. Anyways, persons who peace officers have probable cause to believe have prevented or interfered with an individual's ability to place a telephone call in an emergency. Yeah, that's interfering with a 911 call, actually, if the offense is not committed in the presence of a peace officer. If the person who makes a statement to a peace officer that would be admissible against the person under Article 3821 and establishes probable cause to believe the person has committed a felony. A peace officer shall arrest without a warrant a person... Okay, so this is quite lengthy. Clark overruled by Gerstein.
Write that down, people. Definitely keep this in your back pocket.
While Clark versus State appears to do away with an examining trial on a misdemeanor, however, a 1967 case was rendered ineffective by the decision of federal courts in Gerstein versus Pugh, which reads in pertinent part as follows. Maximum protection of individual rights could be assured by...
Now, just so you guys understand this, right? And again, I'm hearsay. Do your own research. Okay? 1967, they say it's Federal Rules of Procedures. All right? Which gives the officers the right to basically take you to jail. However, this right here is saying, not so fast. But they still use the updated version, and they changed it to this one back. So you got to keep this in your back pocket. Okay, this is the reason why you could still say, I need to see the magistrate right away.
Requiring a magistrate's review of the factual justification prior to any arrest, but such a requirement would constitute an intolerable handicap for legitimate law enforcement. Thus, while the court has expressed a preference for the use of arrest warrants when feasible, it has never invalidated an arrest supported by probable cause solely because the officer failed to secure a warrant. Under this practical compromise, a policeman's on-the-scene assessment of probable cause provides legal justification for arresting persons suspected of crime, and for a brief period of detention to take the administrative steps incident to arrest. Once the suspect is in custody, however, the reasons that justify dispensing with the magistrate's neutral judgment evaporate. There no longer is any danger that the suspect will escape or commit further crimes while the police submit their evidence to a magistrate, and while the state's reasons for taking summary action subside, the suspect need for a neutral determination of probable cause increases significantly. The consequences of prolonged detention may be more serious than the interference occasioned by arrest. Pretrial confinement may impair.
Okay, in short, right? This said, me or you, right? Needs a neutral. You know, an officer says he's got probable cause. Prosecutors basically say he's got probable cause, but you have a right to actually have a neutral party in there. Someone's not trying to put you in jail. The officer's trying to put you in jail. Okay? You're trying to stay out of jail. So the magistrate needs to be between both of y'all. Alright? And say, okay, does the officer have enough probable cause to go ahead and take you to the jail? Right? This is even supposed to be before you see the jail, which is violating of. And then when you go in there, next day, you know, you see the magistrate first thing in the morning. First thing they ask you is, you plead guilty, no contest, you know, all this kind of stuff, right? And the magistrate is only going by the officer. He's not being neutral, people. So when you go to the magistrate, if the officer will do so, he won't. But if he does do so, this is the reason why you can file a claim against the officer. He did not give you due process. He did not take you directly to the magistrate to get a neutral party about the probable cause, right? The officer's executive branch. He cannot make a legal determination, even though they're saying he can, right? But he's still an executive branch. Okay? So, this is what you got to basically say. Did that officer have did the officer have first-hand knowledge of any crime being committed in his present? Right? All right. So, you know, you guys can kind of fill in the blanks on that. If you get to see the magistrate and they don't ignore you. Okay? But in general, that's what it is. You're allowed to have a neutral party. Cops trying to take you to jail. You're trying to stay out of jail. Cops can't make a legal determination. You cannot make a legal determination. So the magistrate's got to go in the middle. Say, okay, well, your subject, wink, 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 and he's got a valid question here. Did you see him commit a crime in your present? So on, so on, so on. All right, you guys can fill out the blanks.
The suspect's job, interrupt his source of income, and impair his family relationships. Even pretrial release may be accompanied by burdensome conditions that affect a significant restraint of liberty. When the stakes are this high, the detached judgment of a neutral magistrate is essential if the Fourth Amendment is to furnish meaningful protection from unfounded interference with liberty. Accordingly, we hold that the Fourth Amendment requires judicial determination of probable cause as a prerequisite to extending restraint of liberty following arrest. So, in other words, that's the federal court that said that.
Remember this, y'all, even with all this going on and passing out all these trickery of words, right? This is statutes. they're not literally actually going by the Constitution. This is all kind of challenging statutes. Well, show me verifiable proof I'm involved in your statute.
Statutory and due process duty to take the magistrate as shown above when a freeman, male or female, is restricted at their liberty under force of law without regard to the rights of the person arrested. The arresting officer has a statutory duty to take the person arrested directly to the nearest for an examining trial by a neutral magistrate, where a person is
directly to the magistrate, people. Not directly to jail. Directly to the magistrate. Listen to the words carefully. Alright? That officer has a duty to take you to the nearest magistrate. If he's got to call that magistrate 3 o'clock in the morning and wake up that judge or magistrate, then that's what he's got to do. And you got to challenge it, people. You got to tell him 3 times or plus, right? Then, if he does not do this, now you can hold that officer of violating your due process, right? Justice delayed is justice denied. He just denied you your due process, so there you go.
Been arrested without a warrant or on a warrant of county issuance, the arresting officer is required to take the person directly to the nearest magistrate by the most direct route.
Again, most direct route. Some counties don't have a judge, magistrate, living in their area. Okay, in my area, it's the same way. So, like in my town, they must either call the magistrate, and the magistrate will say, hey, you know, I cannot go into that jurisdiction, it's too far away. Then the officer must go into the other jurisdiction to take him to the nearest magistrate. Okay, our magistrate is got in 2 different counties. All right, they're close together, so it's not too far away. However, there you go. All right, they are on call 24 hours a day, 7 days a week. Or they cannot issue a warrant 3 o'clock in the morning, people. And if they can wake up at 3 o'clock in the morning and get somebody to break in your house, by gosh, they can wake in the morning and make a bipartisan decision, probable cause.
In the instant case, the arresting officer had a duty to take the person arrested before the nearest magistrate or released under Article 14.06, or on a promise to appear before some magistrate at a time and place stipulated so that a proper examining trial can be held.
Alright, I'm going to do that. It's a lengthy video, so I just want to give you a little snippet. Okay, some of y'all don't like to watch long videos. But we're on pause on this, read some more of that, and add to it, whatever. Alright? This is obviously Texas, so you know, your states, you're going to have to look up yours, but every state's basically like this, right? It's due to that 1967 federal court, all that. So write that down for whatever state you are in. Okay? Alright, this is Decent with People News. Remember, this is an educational video only, okay? I'm not an attorney, I'm not giving legal advice, it's just my opinion. Never look straight forward, always look around you, be able to protect yourself by any means necessary. Alright, till next time. Bye, y'all.